If you're a green card holder and your heart is racing right now because of scary headlines about new immigration laws, I need you to stop scrolling, stop panicking, and listen to me for the next few minutes. Because what you've been reading online is only half the story, and the half you're missing could be the difference between sleepless nights and peace of mind. If you've been seeing headlines saying a new U.S. immigration law just passed that could impact green card holders in 2026, and you're feeling scared, confused, or unsure about what this means for you or your family, I want you to take a breath. You're not alone in feeling this way, and I'm here to walk you through exactly what's happening, what's real, and what you actually need to know. My name is Fernando, and this is U.S. Policy Brief, where we bring you fact-based immigration news without the panic, without the rumors, and without the noise. Let's talk about what's really going on. So, what is this law that everyone is talking about? The reality is that in January 2026, several significant immigration policy modifications have either taken effect or are being implemented by the Department of Homeland Security and USCIS. These are not all brand new laws passed by Congress in the traditional sense. Some are executive actions, some are agency rule modifications, and some are policy directives that impact how immigration benefits are processed and reviewed. The reason people are saying a new law just passed is because these modifications became effective recently, and the impact is being felt right now by people going through the immigration system. Let me be very clear about what's actually happening. First, there is a pause on the processing of certain immigration applications from a list of countries that the U.S. government has designated as requiring heightened vetting. This list started with 19 countries and was recently expanded to include 20 additional countries, bringing the total to 39 countries. The pause affects applications for visas, green cards, citizenship, and asylum. The countries added include several African nations such as Angola, Nigeria, Senegal, Tanzania, and Zimbabwe, among others. This policy went into effect on January 1st, 2026, and it applies to pending applications, meaning applications that are currently being reviewed by USCIS. Now, let me address the biggest source of confusion. This does not mean that if you already have a green card from one of these countries, your green card is being taken away. That is not what this policy does. What it means is that if you have applied for a green card, a visa, or citizenship, and your application is currently pending with USCIS, and you are from one of these 39 countries, your application is being held for additional review. USCIS is not processing these applications in the normal way right now. They are conducting what they call a hold and review process, which means they are taking extra time to verify information, check backgrounds, and ensure that applicants meet all eligibility requirements. Additionally, USCIS has announced that they will be re-reviewing cases that were approved going back to 2021. This means that even if your case was already approved, if you are from one of the affected countries and your approval occurred within the last few years, USCIS may take another look at your file. This is causing a lot of anxiety, and I understand why. But let me explain what this typically means in practice. A re-review does not automatically result in a denial or revocation. What it means is that USCIS is double-checking the file to make sure everything was done correctly the first time. In most cases, if your case was legitimately approved based on accurate information and genuine eligibility, a re-review should not modify that outcome. However, if there were errors, missing documents, or issues with the original application, those could potentially be flagged during the re-review process. Now let's talk about green card holders specifically, because that's what the title of this video focuses on. If you are a current green card holder, meaning you already have your permanent resident card in hand, this policy does not revoke your status. You do not lose your green card simply because of where you were born or because of your nationality. That is not how U.S. immigration law works. A green card can only be revoked or taken away through a formal legal process, which involves reasons like fraud, criminal convictions, or abandonment of residency. It does not occur automatically because of a policy modification. However, green card holders are being impacted in other ways. Starting on December 26, 2025, all non-US citizens, including green card holders, are now required to have their photographs taken by Customs and Border Protection every time they enter or exit the United States. This is a biometric screening measure that applies to everyone who is not a US citizen. For green card holders from the 39 countries on the heightened scrutiny list, there is additional questioning and review at ports of entry. This means that when you travel internationally and return to the US, you may experience longer wait times at the airport, more detailed questioning from CBP officers, and in some cases, secondary inspection. I want to be very clear about what this means for your day-to-day life. If you are a green card holder in good standing, meaning you have not committed any crimes, you have not committed fraud, and you have maintained your residence in the United States, you should still be able to travel internationally and return home. The additional screening is inconvenient and it can be stressful, but it is not the same as being denied entry. CBP officers are conducting more thorough reviews, but as long as your green card is valid and you meet the requirements for maintaining permanent residency, you have the legal right to return to the United States. That being said, I do want to give you some practical advice about travel if you are a green card holder from one of the affected countries. First, make sure your green card is not expired or close to expiring before you travel. If your card is expiring soon, consider renewing it before you leave the country. Second, carry evidence of your ties to the United States. This can include things like proof of employment, lease agreements, utility bills, tax returns, or anything that shows you reside and work in the U.S. Third, be prepared to answer questions honestly and calmly. CBP officers may ask you about your travel, your residence, your employment, and your intentions. Answer truthfully and provide documents if requested. Fourth, if you plan to be outside the U.S. for an extended period of time, be aware that absences of more than 6 months can raise questions about whether you have abandoned your residency. If you need to be outside the U.S. for a long time, consider applying for a re-entry permit before you leave. Now, let's address another major modification that people are talking about, and that is the new biometric exit tracking system. This system is not just for green card holders from specific countries. It applies to everyone who is not a U.S. citizen. Every time you leave the U.S., whether by air, land, or sea, CBP is now collecting your biometric information, including photographs. The purpose of this system is to track who is leaving the country and when, which helps the government identify people who overstay their visas or violate the terms of their immigration status. For green card holders, this system also helps track how much time you are spending outside the United States, which is important because spending too much time outside the US can result in the loss of your green card. Here's what you need to understand about this. The US government has always had the authority to track entries and exits. What's new is that they are now doing it more systematically and with biometric technology. This does not modify the regulations about how long you can be outside the US as a green card holder. The regulations are the same as they have always been. What is modified is the government's ability to enforce those regulations more effectively. Let me also address some rumors that are circulating on social media and in immigrant communities. One rumor is that green card holders from certain countries are being deported at the border. This is not accurate. Deportation, which is formally called removal, is a legal process that requires a hearing before an immigration judge. You cannot be deported simply by showing up at the airport. What can occur is that you can be placed in what's called deferred inspection or secondary inspection, where CBP officers ask you additional questions and review your documents more closely. In some cases, if there are serious concerns about your eligibility to return, you could be referred to an immigration judge for a removal hearing. But that is not the same as being immediately deported at the airport. Another rumor is that green card holders are being forced to give up their cards at the border. This is also not accurate. If a CBP officer believes that you have abandoned your residency or that your green card was obtained fraudulently, they can refer you to an immigration judge, but they cannot simply take your card away on the spot without due process. You have the right to a hearing, the right to present evidence, and the right to have an attorney represent you. Now, let's talk about what's happening with new green card applications. If you have applied for a green card and your application is currently pending, the processing time is likely going to be longer than it was before, especially if you are from one of the 39 countries on the heightened scrutiny list. USCIS is conducting additional background checks, requesting more evidence and taking more time to review each case. This means that if you were expecting a decision in a few months, it could now take a year or longer. I know that's frustrating, especially if you have been waiting for a long time already. But this is the reality of the current processing environment. If your green card application is based on family sponsorship, such as an I-130 petition filed by a U.S. citizen spouse or parent, you need to be aware that the requirements for proving the legitimacy of the relationship have become stricter. USCIS is now requiring more extensive documentation, including things like joint bank account statements, lease agreements showing both names, photos together over time, affidavits from friends and family, and in some cases, additional interviews. If you're in the process of applying, make sure you are submitting as much evidence as possible up front to avoid delays or requests for additional evidence. If your green card application is based on employment, such as through an employer sponsorship, you should be aware that USCIS is scrutinizing these cases more closely as well. They are looking for evidence that the job is real, that the employer is legitimate, and that you are qualified for the position. Make sure that your employer is providing complete and accurate documentation, and be prepared for the possibility of site visits or additional verification steps. Now let's talk about another policy that is causing concern, and that is the pause on immigrant visas for 75 countries. This is a separate policy from the USCIS application pause, and it affects people who are applying for immigrant visas through U.S. consulates abroad. An immigrant visa is what you need to enter the United States as a new green card holder if you are outside the country. If you are inside the U.S. and adjusting status, this policy does not apply to you. But if you have an approved I-130 petition and you are waiting for a visa interview at a U.S. consulate and your country is on the list of 75 countries, your visa processing is currently paused. This pause went into effect on January 21st, 2026, and there is no end date set at this time. This is particularly difficult for families who have been separated and are waiting for their loved ones to be able to join them in the United States. If you are affected by this, the best thing you can do right now is stay in contact with the National Visa Center or the consulate where your case is pending, and monitor official government websites for updates. Do not rely on rumors or unofficial sources. Check the State Department website regularly, and if you have an immigration attorney, stay in touch with them for guidance. Let me also address the confusion around the so-called Trump Gold Card, because this is something that people are asking about in relation to green card modifications. The Gold Card is a new program that allows individuals to pay a significant fee to the federal government in exchange for expedited permanent residency. The standard Gold Card requires a $1 million payment, and there is also a corporate version for $2 million and a planned Platinum version for $5 million. This program went live in December 2025, and it is generating a lot of questions. First, let me be clear. This is not a replacement for the existing green card system. It is an additional pathway that is only available to people who can afford to pay the fee. If you cannot pay $1 million, this program does not apply to you. The traditional pathways to getting a green card, such as family sponsorship, employment sponsorship, the diversity visa lottery, asylum, and refugee status are all still available. The gold card is essentially a way for wealthy individuals to buy their way to the front of the line. Whether or not this is fair is a separate conversation, but the fact is that it does not modify the eligibility requirements or the process for people who are applying through the regular channels. If you are someone who has been waiting in the employment-based green card backlog for years, particularly if you are from India or China, where the wait times are extremely long, you might be wondering if the gold card is worth considering. The answer depends on your financial situation and your priorities. The gold card does offer much faster processing, potentially within weeks instead of years, but it requires a substantial financial commitment. For most people, this is not a realistic option, and the focus should remain on navigating the traditional system as effectively as possible. Now, let's talk about what you should actually do if you are a green card holder or if you are in the process of applying for a green card. First, make sure all of your immigration documents are up to date. If your green card is expiring within the next 6 months, file for a renewal as soon as possible. If you have modified your address, make sure you have filed an AR-11 form with USCIS to update your address. This is a legal requirement, and failing to do it can cause problems. Second, if you are planning to travel internationally, review the requirements for maintaining your green card status. Make sure you understand how long you can be outside the US, and if you need to be gone for an extended period, consider applying for a re-entry permit. Keep copies of all your travel records, including boarding passes and passport stamps, so that you can prove when you left and returned to the US. Third, if you have a pending application with USCIS, check your case status regularly on the USCIS website. If you receive a request for evidence or a notice of interview, respond promptly and completely. Do not ignore USCIS notices and do not assume that everything is fine just because you haven't heard anything. Processing times are longer right now, but that doesn't mean you should stop monitoring your case. Fourth, be very careful about who you trust for immigration advice. There are a lot of people on social media, on YouTube, and in immigrant communities who are spreading misinformation, either because they don't know the facts or because they are trying to profit from people's fear. If you need legal advice, consult with a licensed immigration attorney. Do not rely on notarios, immigration consultants, or unlicensed individuals who claim they can help you. And do not pay anyone who promises you a guaranteed result or a shortcut to getting a green card. Immigration fraud is a serious problem, and it can result in the denial of your application and even criminal charges. Fifth, stay informed by checking official sources. The USCIS website, the State Department website, and CBP's website are the most reliable places to find accurate information about immigration policies and procedures. You can also check congress.gov if you want to see the text of proposed or enacted immigration legislation. Do not rely solely on news headlines or social media posts, because these are often incomplete or misleading. Now, let me address a question that I know many of you are thinking, which is whether these policies are permanent or if they might modify. The honest answer is that immigration policies can and do modify, sometimes frequently. Executive actions and agency policies can be reversed or modified by a new administration or by court rulings. Laws passed by Congress are harder to modify, but they can also be amended or repealed. What this means for you is that the situation today may not be the same as the situation next year or the year after that. However, I also want to reassure you that immigration regulations usually do not modify overnight. And when they do modify, there is typically a process that allows people to adapt. Most significant modifications are announced in advance. There are public comment periods and there are transition periods. The modifications we are seeing right now are the result of policy decisions that were made months ago, and the implementation is occurring in stages. If you are in the middle of an immigration process, you will generally be allowed to complete that process under the regulations that were in place when you started, unless a new regulation specifically says otherwise. The key is to stay informed, stay compliant with current requirements, and seek professional help if you are unsure about what to do. Do not make assumptions, do not panic, and do not make major decisions based on rumors or fear. Let me also say this. I know that dealing with the U.S. immigration system can be incredibly stressful, especially when policies are modifying and there is a lot of uncertainty. If you are feeling anxious or overwhelmed, that is a completely normal reaction. Immigration is not just a legal process. It affects your life, your family, your career, and your future. It's okay to feel worried, but I also want you to know that you have rights, you have options, and you have resources available to help you. If you are a green card holder, you have the right to reside and work in the United States. You have the right to due process if there are any questions about your status. You have the right to legal representation, and you have the right to travel internationally and return home as long as you meet the requirements for maintaining your residency. If you are applying for a green card, you have the right to a fair review of your application. You have the right to appeal a denial if you believe it was incorrect. You have the right to submit additional evidence if USCIS requests it. And you have the right to seek help from an attorney if you need it. The most important thing you can do right now is to make sure you are following the regulations, staying informed, and protecting your status. Do not put yourself in a situation where you could lose your green card or jeopardize your application because of something that could have been avoided. Before I wrap up, let me summarize the key points. There are several immigration policy modifications that took effect in January 2026. These include a pause on processing applications from 39 countries, heightened screening for green card holders at ports of entry, new biometric exit tracking for all non-U.S. citizens, and a pause on immigrant visa issuance from 75 countries. These modifications are causing delays, additional scrutiny, and increased anxiety among immigrants and green card holders. However, if you already have a green card, your status is not being automatically revoked. If you're applying for a green card, your application may take longer and require more documentation, but the pathways to getting a green card are still available. If you're traveling internationally as a green card holder, you may face additional questioning and screening, but as long as you meet the requirements, you should be able to return to the U.S. The best thing you can do is stay informed, keep your documents up to date, respond promptly to any USCIS notices, and seek professional legal help if you are unsure about your situation. Do not rely on rumors, do not panic, and do not make decisions based on fear. I hope this video has helped you understand what is really happening with these immigration modifications and what they mean for green card holders. If you found this information helpful, please subscribe to US Policy Brief and turn on notifications so you don't miss future videos. Share this video with anyone you know who might be worried or confused about these modifications. And if you have questions about your specific situation, leave a comment below. I read every comment and I do my best to provide guidance based on the facts. Thank you for watching, and remember, immigration regulations may be complicated, but you don't have to navigate them alone. Stay informed, stay calm, and stay connected to trusted sources of information. I'm Fernando from US Policy Brief, and I'll see you in the next update. If you're a green card holder and your heart is racing right now because of scary headlines about new immigration laws, I need you to stop scrolling, stop panicking, and listen to me for the next few minutes. Because what you've been reading online is only half the story. And the half you're missing could be the difference between sleepless nights and peace of mind.